Suppose you are in a car crash and now you're scrambling to keep up with your doctor's appointments. You've been injured. And then you get the call from the insurance company or a lawyer hired by the insurance company telling you that you need to get an examination done by a doctor that they have chosen. Is that even allowed? Is that something they can do? Well, here to break that down for us, Tom Sinus from Sinus Stramos Law Firm. Good morning, Tom.
Good morning, Todd.
I guess that's my first question. Can they do that?
Well, as the famous lawyer answer would go, it depends. It depends on the kind of case you have, and it depends on where things are within that particular case. Maybe we should first start with something that I still struggle with, which is what should we call these kind of things? The insurance companies almost always call them independent medical examinations. And I, as someone who represents injured people, I have a bit of a problem with that term applying across the board. And the reason I have that is because these type of examinations usually occur when an insurance company or a lawyer hired by an insurance company wants an opinion from a doctor that is not someone who's been taking care of the plaintiff, the patient. And I tend to think that the doctors that we go see are professionals who care about us and who exercise their own independent judgment and professionalism when they're treating us. So I have a hard time with the idea that the doctors who take care of people aren't being independent to begin with. And I also struggle a bit with the idea that a doctor who has never met someone who comes into a situation at the request of an insurance company really can give the kind of perspective on that person that the person's treating physicians can provide. So I tend to call these type of examinations insurance medical examinations because that's the reason that they occur.
And are there rules? Are there certain rules set for these types of examinations, or are they run like you would at your own primary care physician?
There are rules, and they depend on the nature of the claim. So let's start first with a claim for no-fault benefits. We've obviously talked at length about what no-fault benefits are. Under the no-fault law, there is a section of the statute that permits a no-fault insurance company to have someone examined. And I'll read it. The sentence says, if the mental or physical condition of a person is material to a claim that has been or may be made for past or future benefits, at the request of an insurer, the person shall submit to mental or physical examination by physicians. And then it goes on to some other clauses. So the idea there is that the statute says that a no-fault insurer can request that a person claiming benefits be examined. But there are some important principles there. First, the one doing the examining has to be a physician, has to be someone who is licensed to practice medicine. And then there are some other limitations on, for example, the person has to devote at least half of their time to the practice of medicine. That's a change in the statute designed hopefully to accomplish a result where people doing these exams aren't just people who only do insurance exams all day. So in a no-fault claim, yes, a no-fault insurer can request. And if someone has a no-fault claim and they get one of these requests, they should most certainly take it seriously. It's not something to be ignored, but it's also something to be examined carefully to make sure that what's being requested of them is permitted by law. Because, for example, if the no-fault insurance company is asking for someone to be examined by a non-physician, then that isn't permitted by the law. Things are different in a liability claim. And we've talked over the last few weeks about the difference between a no-fault claim and a liability claim. Liability claim being the idea that the victim is pursuing a claim against someone else, maybe say the person who caused the car crash. There, the rules are different. First of all, if the victim is not involved in a lawsuit, then the insurance company for the other driver has no way to require the victim to go to an insurance medical exam. They could ask, the victim could voluntarily choose to, but there's no way to require it. When a lawsuit starts and the victim is now suing the at-fault driver, we have a provision in our court rules. These are, as the term would imply, the rules that govern court proceedings. There's a provision in our court rules that can permit the one side to request that the other side undergo a medical or even psychological examination. The rule technically requires that the party who wants the exam show that there is good cause, but usually trial courts permit these type of examinations once a lawsuit has been filed. But there are other terms that the parties need to usually agree upon in terms of how these examinations are going to be conducted, when the reports will be generated, and other type of details. So that's sort of a long-winded way of saying that yes, insurance companies can request these examinations, but the rules that govern them depend on the type of claim and where that particular claim is in the process.
Well, if that's you, if you're getting those calls saying, hey, we'd like you to go see this other doctor, and you're not sure if you should or not, as you heard, it does depend on the type of case. You really want an expert who knows this stuff frontwards and backwards. How can people get a hold of you, Tom?
Well, they can find us online at www.sinusdramus.com. We have some good resource material there. They can give us a call at 616-301-3333 or shoot us an email at info@sinusdramus.com.